Good afternoon. I hope you all got some dessert. Fabulous. It'll keep you awake too right after lunch, right? You need the sugar. Don't want to put you to sleep. So thank you once again for having me here at the plenary. I really do appreciate it. I really enjoy coming to see you. And I have quite a bit of ground that I'd like to cover today. Just to give you an indication of the bigger picture priorities for this term, I want to talk a little bit about some of the regulatory activities where we're seeing trends in conduct and competence streams. I'm going to go over some new policies and programs that have been approved and are either currently in development or will be in development shortly. And finally, I want to talk just a little bit about a significant change in our operations that's going to have an effect on licensees, but will work to reduce burdens and create efficiencies for both licensees and the Law Society. So let me just start with the Law Society's strategic priorities. Following the commencement of every new board term at the Law Society, we engage in a strategic planning discussion to develop a set of goals or priorities for the four-year term that the benchers are there. Convocation this year and last year settled on those in the latter part of the fall, and following further discussions has begun to align our current work to those priorities and also consider any new policies, any new programs or activities that we might actually want to consider to be able to achieve our mandate vis-a-vis each of those priorities. It was actually a very succinct and streamlined strategic plan outcome for this term, predominantly because the issues of importance became very clear very quickly, and also because we have a lot going on right now at the Law Society to support ongoing approved protocols that are in process and now are being developed and implemented as we speak. So I'll actually get to some of that work later in the presentation, but let me just walk you through the three priorities that Convocation has actually set for the 2023 to 2027 term. Our first goal in the strategic plan is clear and direct: governance. The objective is actually to review the current governance structure of the Law Society and how that supports our ability to be a proactive and appropriate modern regulator with appropriate regulatory responsibilities supported. And that includes taking a look at the current election process. This is about enhancing accountability and focus to ensure that we are able to realistically achieve all of our regulatory objectives as we carry out our legislated mandate. And the goal is already well underway because we have had a governance review task force in place since shortly after the new board started last year, and that task force is planning on making recommendations likely in the fall of this year. So the next priority that we've chosen is regulation, which seems rather logical given that we are a regulator, of course. But the point behind this goal is actually to focus more directly on aligning competence and conduct streams so that we're maximizing our ability to assist licensees to be their most competent, and then tying that more closely with what and how we address misconduct in a manner that's more risk-based and proportionate to the level of harm that's actually been caused, with a focus on the most appropriate application of our limited resources. Well, we do this now, and we've always been doing this. The explicit commitment here in this priority is to integrating the model so that we are looking at the entire continuum of licensee practice and ensuring that we are focusing our resources on those items that will best support the public interest as we move forward. So in this area, I expect that we might see some increasing discussions on how to direct or redirect sources and resources to support increased and more defined remediation efforts, how to redirect disciplinary matters to determine if we're able to remediate a licensee situation and have them take required steps and may even be evaluated for improvement, all without necessarily having to go through the full conduct process and to a hearing. And finally, to ensure that those matters that we are dealing with that are significant harms, so trust fund defalcations, sexual misconduct, for instance, come to mind, those will be appropriately and swiftly dealt with in the process. And we already have a number of new risk-based protocols in place that will actually do that. And we're also embracing a new approach that will ensure that our complainants will not be re-victimized by the situation that they find themselves with their licensee, and that we're providing supports to all of those complainants and the licensees who have been harmed, and that they're assisted through the process and they're able to come to closure with more understanding of the reasons why a certain conduct route was taken by the regulator, by the Law Society. And the final priority, the third priority, is access to justice, within which the goal is to support an effort to always ensure that we're thinking about underserved people and communities and how we as a regulator will be able to facilitate broader legal services coverage for those groups. And that includes increasing options for provision of services, supporting innovations in this space, promoting right touch regulation, which means essentially avoiding overregulation, and ensuring that we're not standing in the way of opportunities. So those are the terms and the set of priorities that we're working with, and the board, together with management, will start to develop tactics, and we'll try to bring these to life as we move forward. The next thing I'd like to do is just touch on some regulatory trends, both in the conduct and the competence areas. As I usually do in the spring, I want to just take a look at a few trends so that you can all see where the legal profession is moving to and where the pressures of regulation are actually resting these days. So we'll start actually with professional regulation or conduct, and in particular with complaints, because we are seeing a noticeable increasing trend in complaints. Even setting aside the difference in complaints between 2022 and 2023, which you'll see there on the slide, let's assume 2022 may have been a bit of a blip of sorts, but the trend line overall is on the definite rise, at least 6% or more on average every year. Of the complaints that are closed, about 30% of those were found to have insufficient evidence to warrant further regulatory action. But of course, we have to remember that we have to do all of the foundational work and interactions and investigations with the complainant and the licensee to actually be able to come to that conclusion. A further 10% achieved a resolution as between the complainant and the licensee with the help of our intake and resolution team. 6% received regulatory guidance. That's where we have actually found an issue, but one that does not rise to the level of further regulatory investigation. But it also has to be corrected to avoid future occurrences. So we would provide the licensee with recommendations for change and recommendations for improvement. About 50% of the closed complaints were actually closed because they were outside of our jurisdiction, or because there was already ongoing concurrent external litigation, or the complainant withdrew the actual complaint. So just breaking down these complaints a little bit more, 70% of the 6,500 complaints we received last year were about lawyers. 11% were about paralegals. 19% were actually about non-licensees. So that's either licensing candidates or individuals who are actually not legal professionals. It's unauthorized practice. About 80% of the complaints are coming from the public. 9% are actually brought forward by other licensees. And about 13% of the complaints actually are derived internally by the Law Society itself. And so, as you can imagine, those would usually be extreme matters. Now, I think the good news still remains that only a small number of licensees overall actually receive complaints. Of the now 70,000 licensees that we have registered with us at the Law Society, only 5% of lawyers received a complaint, or looking more closely to only those in private practice, just under 10% of lawyers received at least one complaint last year. And the areas of law within which those licensees who receive complaints are practicing is predominantly real estate and civil litigation. Overall, our professional regulation area is actually achieving excellent benchmarks related to their age of inventory with their files. 89% of all complaints are resolved or referred for a disciplinary or a remedial response within 12 months. And that's 9% better than the national benchmark that was set as the standard for all law societies across the country. One last thing in regulation that I'd like to talk about, and that's the compensation fund. Just a reminder to all of you, and if you could take this back to your local areas, that when our colleagues do something dishonest and clients suffer losses as a result of that inappropriate conduct, we're all paying for it. Our compensation fund, which is the fund that supports paying back clients who have suffered a loss, continues to see significant applications for repayments. You can see here that the 2023 numbers have once again shot up. This is a direct result of a pandemic bounce. It takes about 2 to 3 years for our repayments to take place, starting with the request from the client that comes into us following an investigation that has in fact confirmed the loss that's incurred by each individual. And then the Law Society takes that request from the complainant and processes it to ensure how much is owed and why. and then we'll pay out those grants to the clients. So the increase you see here in 2023 are actually the losses that would have occurred likely in 2020 or 2021, and we're just seeing them now in 2023. Now, whenever we have a crisis, whether it's a pandemic crisis or an economic crisis, we do tend to see an increase in claims to the compensation fund. The fund is trending high again in 2024, I'm sorry to say, and we will have to see where that goes. As you know, our compensation fund has strict fund limits that have to be maintained in the event of a major crisis happening. And when the fund is reduced, that means that the Law Society has to increase the annual fee for licensees related to replenishing this particular fund, all because our colleagues have done bad things. So a reminder again that we have an obligation individually as well as licensees to proactively report inappropriate conduct of licensees if and when we see it. We would certainly like to get ahead of these losses if it's at all possible. So let's move on now to professional development and competence. And I just want to chat a little bit about licensing. There continues to be an ever-increasing number of individuals seeking to become licensed as lawyers, with over 6,300 active candidates in the process at any one time, and it continues to climb. Articling placements are continuing to be in the range of 8 to 10 months, with about half of them at the 10-month period and about the other half at 8 or 9 months. We instituted as well mandatory minimum compensation for articling candidates in an effort to ensure that those candidates were not taken advantage of, and the vast majority of candidates are being paid in accordance with the minimum requirement, which is $620 per week. We do have situations that are exceptions, and an articling principal can apply for a modification or an exemption to that minimum payment in certain circumstances. We also have a new resource that some of you and your members might be interested in, and that's the Guide to Experiential Training, which is meant to assist in particular new articling principals to make the most of using an articling candidate's skills and also support that candidate to learn and grow. And there are quite a few members and firms who have accessed that, so I'd certainly encourage you to take a look at that. And just speaking of experiential training, there are multiple pathways for lawyer licensing candidates to fulfill the requirement, and I thought it might be interesting to show you how that actually breaks down. We've had over 2,100 candidates start an articling placement in 2023. That number of placements does continue to grow, but slowly, and it does not meet the need, nor has it ever met the need for placements for decades. So we do have alternatives. And we had over 250 licensing candidates in the law practice program at TMU, Toronto Metropolitan University, and we had 8 in the French equivalent of that program at the University of Ottawa. And we had almost 190 licensing candidates who completed the experiential training program through an integrated practice curriculum, which is at one of the 2 law schools that provide this option, and that's at Lakehead and TMU. Overall, you can see at the bottom there that we licensed 2,554 new lawyers in 2023. Welcome them into the profession. But just stepping back to take a quick look at where all of these licensing candidates are coming from, I mentioned that we had over 6,300 candidates moving through the process last year. Of those, 2,814 of them were newly registered in 2023. And of those newly registered candidates, almost 40% of them graduated from a law school outside of Canada. The areas of the world from where we continue to receive the most internationally trained candidates continues to be the UK and Australia, followed by locations in the Indian subcontinent. A quick look at paralegal registrations for you as well, because I think it's important to understand the entirety of the legal services market in Ontario and how it's growing. Our colleagues in the paralegal profession continue to increase in numbers, and when we look at the individuals who are registering and being licensed at a much smaller percentage of increase, but still increasing in the licensing process. Unlike the new lawyer candidates and licensees, however, fewer new licensed paralegals go into or remain in independent practice. In other words, they do not open their own practices or work with other paralegals in private practice after they've been licensed. I just want to switch now for a minute to talk about some resources. I like to just remind everyone about the resources we have and how they're doing so that you can spread the word with your colleagues. So a shout out again for the Coach and Advisor Network, or CAN. which is supporting significant numbers of soles and small firm practitioners to maintain good practices and obtain assistance they require, particularly helpful when you do not have others close by that you can turn to for help and advice in your legal practices. Critically, 82% of our volunteers in CAN are actually sole or small firm practitioners, and that does ensure that we can provide those who need this assistance with really practical and knowledgeable advice about their issues or situations in the context of their actual practice circumstances. We completed over 850 engagements last year, and 90% of those who sought assistance were sole and small firm practitioners. And you can see that we have a lot of satisfied users of the system as well, given that over half of them requested support more than once in a calendar year. If you would please remind your lawyers and paralegals in your local areas about the service, it can be invaluable, particularly to those who are just starting out or transitioning, or those who are experiencing difficulty in their practices with their clients. And I didn't put a slide in today for the member assistance program, but always remember that if licensees are having difficulties, personal difficulties or otherwise, they can certainly be encouraged to reach out for assistance and counseling to MAP. Now, I just wanted to move on to some new developments because they represent new obligations as well, and just bring you into that loop. The Law Society has just recently approved a new requirement for client contingency planning. All licensees in private practice are going to be required to have a contingency plan in place for 2025. You'll be required to report that you do have a contingency plan in place in your reporting for that year, which is actually completed not until the early spring of 2026. The extent of the reporting is just a checkbox on the annual report. Do you have a plan or don't you have a plan? There's no requirement to file a plan or provide the Law Society with any documentation. Unless we come out to audit you, in which case, commencing in 2026, you can expect that our auditors are probably going to ask you a little bit about information on that plan. The focus of this effort is on one of the most significant emerging areas of risk that we see as a regulator, and that's the aging of the professions and the increasing incidence of practices being abandoned due to illness, incapacity, or death of the lawyer or paralegal. The Law Society is going to be providing templates and supports to assist with all of this as the year progresses. And the key item is that licensees will be required to designate an administrator. For those in firms with more than one licensee, that will simply be another lawyer in your firm. For those in firms with one licensee only, we of course acknowledge that there may be more challenge in finding an administrator, but we note that the functions of the administrator are only threefold: to notify the Law Society and the insurer that something has occurred, to notify the clients of that practice and return or transfer property as directed by that client, and to attempt to access the trust accounts and return or transfer trust funds. And as is always the case, the Law Society's Trustee Services Group will be there to help all licensees put a plan in place, look for an administrator, and also help those administrators to wind up the practice if it's required. So the next program that we have is Foundations of Sole Practice, and I just want to spend a moment here. This pertains to those who designate into the sole practice status. It's a mandatory 30-hour online course. It's interactive, it's self-paced, and it's practically oriented. And the modules will address the areas of practice that result in the highest incidence of complaints and negligence claims and identify practice deficiencies. And those include areas like professional obligations, business matters, money matters, managing your clients, and managing risks and change. This is a recommendation from the Competence Task Force, which identified a gap in training, particularly for new calls. It stems from a desire to set licensees up for success from day one, with a focus on having a positive impact on competence, so supporting better public protection and having fewer complaints and claims over time. Our Law Society data does note that sole practitioners make up about 1/3 of lawyers in private practice. It's about 32%. However, they are subject to almost 50% of all complaints received against lawyers. And more importantly, lawyer sole practitioners make up over 75% of the complaints that actually result in a discipline proceeding. For paralegals, quite similar, slightly over half of paralegals are actually in private practice as soles. They are subject to 70% of all complaints received against paralegals, and once again, over 75% of the complaints that actually result in a discipline proceeding. This is a proactive mandatory requirement, not retroactive. So licensees declaring in 2025 that they've joined or have moved to the sole practice category will have until the end of 2026 to complete the course. After 2026, licensees who declare before June 1st must complete the course in the same calendar year, and licensees who are declaring on or after June 1st of the year will have until the end of the following year to complete the course. Licensees who are doing this, our sole practitioners who are just starting out, will also be permitted to apply the CPD hours for this course across 2 calendar years. So they're going to be able to roll those hours over as they're training. And the outcome of failing to do the course will be an administrative suspension that can be cured by doing the course. So keep an eye out for that. I think it's going to be a very positive learning experience for everyone who takes it. We're working very hard to make it a very integrated, very adult learning-oriented program that I think will be very helpful with lots of takeaways for new sole practitioners. I also wanted to chat a little bit about our new digital toolkit. We're really pleased to note that the Law Society has developed a series of generative AI tools for licensees to assist in navigating the burgeoning use of these tools in our practices. In the slide deck that's posted for you today, there are actually direct links to our digital toolkit providing guidance on professional obligations, practical steps and ideas for integrating generative AI into your work, and also best practices to minimize risks. And the resources themselves actually focus on providing really practical tips, a get start sort of a tip sheet. Nothing is surprising here because we all know that this is an area in which we all have to do some learning. But as we do all learn to navigate the use of the generative AI tools that are coming forward, it never hurts to be reminded of the basics of both practicing law and practicing law with tools that are new to us and have to be appropriately applied as we explore their opportunities. As is always the case, the rules of professional conduct require all of us to keep up with the changes in practice, including new technologies. And to use these tools responsibly on behalf of our clients, you do have to know quite a bit about them. So here are the themes that you'll consistently see in our toolkit. It's about competence and learning the ins and outs of any new practice tools. It's critical for proper usage and the control of your practice. Confidentiality, of course, is always paramount, so know where the information that you're putting into this machine is going to end up, which may be in the public domain unless your AI is an internal product. And make sure anything you put into the tool is not client-specific confidential detail if you're dealing with a public AI product. Human oversight, therefore, remains critical to managing the risk here. You remain responsible for all of your work product and those of your employees, no matter how you generate it. And of course, always engage in ongoing learning. Make sure technology is evolving. Make sure your technology in your firm is evolving as well as your own knowledge of it is evolving, because it is moving quickly and you do have to keep up and make sure you're adapting accordingly. I also threw in another slide here with a few other links just for some other resources in case you were interested in shooting them around to others. I'll leave you with that here. There are some other key resources that the Law Society can provide support to members, especially the Practice Management Helpline, which continues to get a lot of calls from sole and small practitioners. It's just for your use, and that's just my final note in relation to new developments and products. So finally today, I had one other matter that I wanted to just address with you, and that's something new at the Law Society. This summer, the Law Society is going to start LSO Connects, which is the Law Society's new secure online communications channel that will be rolled out to all licensees and licensing candidates. Your new LSO Connects account is going to allow you to securely complete your administrative requirements and obligations and all of your business transactions with the Law Society, as well as communicate with the Law Society at your convenience. The LSO portal, which is what you use now, is going to be retired. The Law Society is upgrading its technology systems because our organization is currently supporting systems that are outdated and inflexible, a lot of legacy systems, and that results in complex and really resource-intensive processes. The new system is going to provide more efficient and reliable online service. LSO Connects will provide you with more self-service options and one-stop access to Law Society services and information, and everything is going to be integrated into the system, including everything to do with disciplinary matters. In the coming months, you'll be receiving information via your primary email address on file with the Law Society, and it'll give you instructions on how to set up your LSO Connects account. So please do ensure that your contact information on the current portal is up to date so that you'll receive this information from us in a timely manner. We are, of course, working hard to support a smooth rollout of our new technology system, which is enterprise-wide, but as with all large technology systems, there may be a few bumps, and it is going to be a learning experience for everyone. So we'd ask for your patience and support as we go through the transition, and always remember that we're there to help you make the transition. So please let us know if you need us to assist you. You know where we are. You can contact us by email and also by phone, whatever's easier for you. And that's it for me today. I'm going to sum it up there. And I'll ask if there are any questions from anyone.
Hello, my name is Kathy Batiki, and I'm specifically asking you a couple of questions about family law, because that's what I practice.
Sure.
Two issues. Non-licensees practicing family law through the back door of training as a mediator, becoming a mediator, advertising themselves as a mediator, and then when mediating, convince the parties to not consult a lawyer and to let them draft the separation agreement. That to all of us that I know find that as to be a non-licensee wrongfully practicing law. Is there anything that the Law Society can do about that?
If they are actually practicing law and providing legal advice to their clients, then the route is to file a complaint against them, if that's actually the case, because that is unauthorized practice, if they're not a licensee.
Okay, so that when one of the clients comes to a lawyer to say, I don't like the terms of the agreement that I actually signed, or they start fighting about it, and we find out that it was a non-licensee who drafted the agreement as a mediator, then that's when we would contact the Law Society.
You can contact the Law Society and advise us that someone who's not an authorized licensee has actually prepared a legal document, yes.
Okay, and the other question I have is just quickly about bar admission course. Teaching young lawyers specifically about family law, specifically about the rules of practice, and specifically about practice directions. The dilemma that I see, and I don't know if you know, but there's a Facebook page for family law lawyers in Ontario that was created during the pandemic, and it is still very much used, particularly by young lawyers who don't know necessarily what they're doing and asking questions. There are so many young lawyers out there that don't seem to even know that there are family law rules out there, don't know what the spousal support guidelines are, and don't know what practice directions are about proceeding to court in different jurisdictions. Is there any way that this can the Law Society can help fix this by having better bar admission materials to cover some of this stuff? I mean, I know the bar admission, I tutor people who don't pass the family law part of the bar admission, so I know generally what the bar admission course covers. But specifically, right now, the practice is so heavily necessary, used by different practice directions around the province that are hard to find just for lawyers themselves, but for young lawyers that don't even know that they exist, it can become a problem. It becomes a problem for the client, because if they don't know what exists, then the client could be prejudiced. So I'm just wondering, I mean, I know you talked about the coaching and the mentoring, but some of it is so daunting that something bigger has to be done, and I'm just kind of hoping that the Law Society could figure out a way. I mentor at the LPP program, and I raise at the LPP program, and they try to cover a little bit of it, but they can't cover it all, particularly if the candidate hasn't even taken family law as a course. Because what happens is they become a sole practitioner. The work that comes through the door is either criminal or family quickly, and they have to quickly learn it, and that is just a risk to the public. I'm just hoping the Law Society could think of a way to help fix that.
Well, we'll certainly give it some more thought. There are an awful lot of resources out there, and mentoring and coaching does help, but I have to say, I hear this about every single practice area. So I hear you, I absolutely hear you, and I know it's daunting, but it's daunting for everyone, and these folks have to pick up on it. But let me take it back, because there's always something more or other that we could do, whether it's through training or testing or assessment. So let me take it back. I appreciate your comments.
Hi, Corey Wall. I'm an estate litigator, and I was just wanted to ask some questions about the succession planning that you've put in place and dealing with trustee services. One of the things that I'm wondering is, I know that the trustee services is getting appointed in cases where we have unsuspected deaths or somebody becomes incapable. And I've provided some feedback before, but I'm curious about with solos in regions where there's not a lot of other people that you can designate, or perhaps those people are already overburdened and can't assist you, is there any reason why the Law Society couldn't try to seek an amendment to the Solicitors Act or something like that that can provide some legal recourse for trustee services to have a more expedited process in the courts when they need to assume those practices?
I think we've had this discussion before, Corey. I don't know that changing the Solicitors Act is going to help us do that. We're moving as quickly as we can. The issue we have is that actually what happens is there's a death or incapacity and we don't find out about it for weeks. And we wouldn't know until the family or someone tells us. So, that's our real gap. It's not so much the Solicitors Act as much as it is an activity, which is why the administrator function is so important. We absolutely acknowledge that there are going to be some areas where it may be difficult to find an administrator, but given the role of the administrator, which is very well defined, it can be outside of your area. It doesn't necessarily have to be in there, because the person's job, think about it this way, the number of times that I've even received calls, or my trustee services have received calls from non-licensee family members in tears because somebody just died and they don't know what to do with the boxes, and it's been weeks, and they just figured out that they needed to call us. If there was someone who was a lawyer in the next city or town or region who just got a call to say, uh-oh, who could help us make the right calls, including to trustee services, we could be in there quickly, right away. Our team mobilizes very quickly. But we don't know what we don't know. Thank you. Thanks for the question.
Hi, Jennifer Bolduc in Waterloo. So one thing that we've noticed is our library staff have been getting more and more calls about people trying to find wills from other lawyers who are deceased. With the new system and the focus on contingency planning, is it possible for a feature to be added to a program like this where somebody could indicate where their wills are going to be, for there to be a database that people could look at to find out where those are going to be stored?
Sure. So we already have a list of where many of the wills in the province are resting, because we have all the files from all the people who did either pass away or give up their practices, and we've got a list of that. And I think there are a few other will registries, but certainly as the administrator is going through, that's going to be a property issue that needs to either be returned to the client and or filed somewhere, likely with the Law Society. I expect our database is going to increase. Our holdings are going to increase in that area. Yeah. You're looking for an independent system, or?
It's somewhere where if let's say PA gets a phone call,
yeah,
there's one place that she can go to.
Well, she should definitely call the Law Society. So you should definitely start with trustee services, because we've got an immense list of wills. Not necessarily all wills for all lawyers, because many of the lawyers have either transferred their wills to other lawyers' offices or are actually working with wills registries, private wills registries, where they're now filed.
And it's the problem is they call the Law Society.
Yeah.
Sometimes they get told, yeah, we'll get back to you, and then you have to wait. And there's no guarantee that it's going to be registered somewhere if they transfer their will
Yes.
to another law office.
That's true.
And that's what I'm saying. Like, if somebody has transferred their will, they know they're retiring, and they transfer it to Smith LLP, why can't they put that in this system so that when people are looking, they can see this person has transferred their wills to Smith LLP?
Sure. In the ideal world, everyone would do that, but they don't. But let me take that back. There's been lots of discussion about wills registries over the years related to trying to coordinate all of this across the province. Appreciate the comment. Yeah.
Diana, a quick couple-part question on the administrators.
Sure.
Because I know some people who I think it'll be a great thing for them to have. One, is there going to be a list maintained by the Law Society? So if John Smith dies and he's got Eldon Horner as his administrator, somebody can find that information if he hasn't shared it with the right people?
Yeah, I mean, well, it's a good question. We can try to ask for that information, Eldon, and right now we do, actually, just so that you all know, the Trustee Services also has an ongoing list of people who are willing to act as administrators. So if you're looking for somebody, you need to contact them, because in the various areas, when someone does die, we have a whole list of people that we blanket and call out to see if they can pick up files and take
Thanks.
care of the client. So do that. Let me take that back as well. What we're trying to do is minimize the amount of effort that, and as you can imagine in doing this, we want to try to balance the public safety issue with burdening licensees. And the more information you have to write down and aggregate and send to us, the harder it gets. So small steps, but yeah, that's a great idea.
Well, I just thought it may be that they just finally appoint somebody, or,
Yep.
and I assume you have to, well, you should call the person, talk to them, get their consent or whatever, but I'm glad to hear there may be people who will act for those people that
Yeah.
don't like any other lawyers
Yeah.
and wouldn't trust them.
Yeah.
So that's good. And then related to that, if I'm an administrator for my friend and he dies, A, are there any rules on what arrangements he and I or she and I can make for compensation? And B, if I'm doing that, even though it's a pretty limited thing you need to do, can I assume that I'm insured when I'm acting as an administrator for another
So-
lawyer if somebody says I should have done something
Sure,
I
you
didn't
can
do?
ask, I mean, Law Pro's here, I think, at another time today, so you
Yeah,
can ask
okay.
about that. But yeah, there will be some information coming out from Law Pro related to this new policy change to give comfort. You know, there is no rules. We're not going to restrict what you do with your friends to coordinate your administrative activities. That'll be up to you. That'll be an agreement. You know, it's all part of good estate planning. It's business planning. Figure it out. Figure out what you need to do. Document it, as good lawyers do. Get it all signed and agree to it, and then you're ready to go. We just want to make sure that the clients whose files have now no support are actually returned to the client, or there's someone else that they've agreed to take over their file. That's critical for us, because we can't have them sitting there. Thanks, Eldon.
All right, this is where we.
Okay,
Thank
we're
you.
done. I'm done.
And
Thank you very much.
It's always a pleasure to have you here at Plenary.